Thank you. Your Excellencies, ladies and gentlemen, permit me to thank the Institute for Diplomacy for organizing this seminar and for inviting me to make a few remarks. The title of my remarks has been given to you, and I will speak to this topic through the lens of my experience as a judge at the International Criminal Court here in The Hague. As many of you know, the ICC is a treaty-based institution with 123 states parties, the latest being Palestine, who acceded to the Rome Statute only this year. I will not go into the debate of what's going on right now. I will leave that to the politicians. I'll suffice it to say that the ICC is designed to determine the responsibility of individuals for the most serious crimes of concern to the international community as a whole. The ICC aims to put an end to impunity for the perpetrators of these crimes and thus contribute to the prevention of such crimes. My remarks will touch upon the basics of how the ICC works, so that just to bring us all on one page, and its role in promoting international law and human rights more generally. The court only has jurisdiction in certain limited situations. Either a state party refers the situation to the prosecutor of the court, the United Nations Security Council refers the situation pursuant to Chapter 7 of the United Nations Charter, or the prosecutor initiates an investigation on his or currently on her own initiative, i.e. proprio motu. In the third case, the pretrial chamber must authorize the prosecutor's investigations. Even when its jurisdiction is triggered, the court has a limited subject matter jurisdiction. That is to say that the court can only exercise jurisdiction over a handful of core international crimes. At this point in time, the crimes within the jurisdiction of the court are genocide, crimes against humanity, war crimes, and the crime of aggression. At the ICC, we have reached a point where the court's jurisdiction has been triggered in several ways. In a number of cases, states referred their own situations to the court. Example is the Republic of Uganda, the situation where the first ICC warrants of arrest were issued, though such warrants were issued by the pretrial chamber almost against some 10 individuals against some individuals almost 10 years ago. It was only last month, January, that the first arrest was made. Other self-referrals include the Democratic Republic of the Congo, the Central African Republic, and Mali. The UN Security Council has so far referred two situations to the court, Darfur and Libya. It is worth noting that although Sudan and Libya are not parties to the Rome Statute, the statute allows the UN Security Council to refer situations of non-party states. The Office of the Prosecutor has sought pretrial chambers authorization to initiate investigations in two situations only so far, in Kenya and Cote d'Ivoire. Just because these grave crimes may be difficult to prosecute at the national level does not mean that it is impossible to have such prosecutions. One of the hallmarks of adjudication at the court is that the ICC is a complementary institution. It is a court of last resort. Cases that fall within the court's jurisdiction may still be inadmissible if, under the circumstances described in the statute, a state is already handling the cases domestically. The easiest way to explain how admissibility works is to think of it as a three-step process. Step 1, cases within the jurisdiction of the court are generally admissible. Step 2, if a state is or has been investigating or prosecuting the same person for substantially the same offense, then the case becomes inadmissible before the ICC. And step 3, the case can become admissible before the court once again if the national authorities are unwilling or unable to genuinely undertake the necessary proceedings. A consequence of the complementarity regime is that it has encouraged state parties to modify their national legislations in order to ensure that they can successfully challenge the admissibility of cases at the ICC if they wish to prosecute them domestically. The ICC is still a relatively young institution, and much of the admissibility test remains unclear, but its potential impact on domestic law is clear. These changes to domestic law can assist in the promotion of human rights. The complementarity principle has had an effect in encouraging states to incorporate the crimes in the Rome Statute into their national penal codes. Australia, South Africa, and the United Kingdom are examples of states which have directly incorporated crimes outlined in the Rome Statute into their domestic codes. In particular, the provisions of crimes against humanity in the Rome Statute have inspired some national legislations. The underlying acts which constitute a crime against humanity, such as murder or rape, have long been defined as criminal in national jurisdictions. However, most of these same jurisdictions did not have a specific set of crimes known as crimes against humanity. Ratification of the Rome Statute has led several states to adopt new legislations based on Article 7 of the statute. The Netherlands and South Africa are two examples of states that have introduced crimes against humanity for the first time in their ICC implementing legislations. Other states, including Spain, Estonia, and Germany, have even gone beyond the Rome Statute, when codifying crimes against humanity by removing the state or organizational policy that requires crimes against humanity to be committed in pursuant to or in furtherance of. This is not a requirement in the ad hoc tribunals. War crimes were considered and treated as crimes more generally in domestic legal systems prior to the ICC, though some countries have also made new provisions for these crimes. I will single out Japan as an example of a country that had particular difficulty with the war crimes provisions in the Rome Statute. The Japanese constitution renounces war as a sovereign right of the nation, which prevented Japan from enacting any legislation that related to war or war crimes. Japan subsequently adopted several pieces of emergency legislation to incorporate international humanitarian law into its legal system before it acceded to the Rome Statute on 17th of July, 2007. As you can see, the ICC's role in international law is inspiring domestic law to a noticeable degree. The existence of the court has also led to states changing their domestic laws to promote the court's work and mission in other ways. Article 86 of the Rome Statute provides that state parties shall, in accordance with the provisions of the statute, cooperate fully with the court in its investigations and prosecutions of crimes within the jurisdiction of the court. This means that states ratifying the Rome Statute have tried to ensure that their domestic legal systems are capable of addressing any cooperation request that the court might make. One example would be the ICC's power to have nationals surrender to the court provided under Article 89 of the Rome Statute. Prior to ratification, many states had prohibited extradition of their nationals. Along the way towards ratifying the Rome Statute, many countries, including Finland, Germany, Slovenia, Belgium, and Norway, have changed existing laws to allow for extradition of nationals if an international treaty requires. Other states have allowed for extradition to the ICC as an exception to what remains a general prohibition on national extradition. The ICC does not require that state parties change their extradition laws, but states have adjusted their laws and constitutions to allow for the ICC to enforce its mandate. It is also to be noted that the ICC cooperation regime can even extend to non-party states under certain circumstances. Article 13b allows for jurisdiction over any situation that is referred to the prosecutor by a UN Security Council resolution. Arrest warrants issued by the court from such referrals can include nationals of a non-state party. Even without a UN Security Council referral, The ICC can also assert territorial jurisdiction over nationals of a non-state party. This means that a non-state party to the Rome Statute can expose its nationals to liability if they commit international crimes on the territory of a state party. Thus, nationals of all states could be subject to ICC enforcement. And non-party states can also assist the court in its work. The United States and Rwanda are examples. In 2013, Bosco Ntaganda, against whom the court had issued an arrest warrant in 2006, surrendered himself to American authorities at the US Embassy in Rwanda. Despite not being formally obligated to surrender Mr. Ntaganda to the court because America and Rwanda are non-state parties, they nevertheless assisted handing over Mr. Ntaganda to the court. This example highlights how all national jurisdictions can assist the court in its work, not just state parties. So from this basic introduction to the ICC, you can see its role in international law and the promotion of human rights. And in order to respect time, I want to thank you all for listening to me. And I want you, for listening to me, tell you how ICC does a lot to support human rights and human dignity. Thank you very much.